Hello, this is Matt on the Moon Lambeau channel. The SEC is throwing a redaction party and you're not invited. Because nobody's invited, because the SEC wants to keep certain information out of the hands of Ripple and apparently the judge, actually. So I'm going to share with you where this is stemming from. There's a legal filing by the SEC letting the judge know, hey, we want to redact specific things. And there's 4 specific instances that they do want to redact. Also, I've got comments from Attorney John Deaton I want to share with you. It's an interesting prediction being made having to do with William Hinman and what's going to happen when he finally has to answer the question of whether or not he knew that his law firm, Simpson Thacher, had interests regarding the Enterprise Ethereum Alliance. Which is relevant because, as you well know at this point, I'm willing to bet pretty much everybody listening is aware, Bill Hinman got $15 million. He was paid $15 million by his former law firm, Simpson Thacher, while he was at a high up position as an official at the SEC. And he made decisions that benefited his former employer. And then when he quit the SEC, he went back to work for Simpson Thacher. So he basically unretired. So this is all highly consequential. Also, the Digital Chamber of Commerce, which is basically, it's in existence to prop up and encourage the adoption of all things cryptocurrency related. Well, they've been surprisingly silent on the Ripple case, but it looks like that's not going to last much longer, and that's probably very good news, actually. So I want to share with you some specifics on that as well. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, shout out and credit to attorney James Filan, member of the XRP community, for sharing this most recent legal document filed by the SEC. And he tweeted it out and he wrote the following. The SEC has filed a motion for permission to redact notes of meetings between the SEC and third parties, claiming the notes are protected by deliberative process privilege. There you go, that privilege argument again. The request is based on the January 13th, 2022 decision on the DPP issues. And so I want to cover just a portion of this, and I actually don't have to read too terribly much to share with you the ideas that I want to share here, but the SEC wrote, Dear Judge Nepern, pursuant to the court's opinion and order of January 13th, 2022, Plaintiff Securities and Exchange Commission, the SEC, respectfully requests leave to redact portions of the handwritten notes taken by SEC staff who attended certain meetings between the SEC and third parties because these portions are protected by the deliberative process privilege. The handwritten portions in question expressly reflect either the author's thoughts regarding subject matters discussed during meetings and or deliberations among SEC staff during meetings. Now, I'm going to read just a portion of the background because this explains why they're going about doing this. Basically, the SEC was effectively, anyway, invited by the court, the judge specifically, to make such claims if they thought that any actually fit within certain parameters. So take a look at the background now. The court's order granted in part and denied in part defendants' motion to compel, which challenged the SEC's assertion of the DPP, that's the deliberative process privilege, among other privileges, as to the documents referenced in Appendix A of defendants' motions. Of relevance here, and this is the part that matters, the court held that the DPP did not shield from production certain sets of notes of meetings between SEC staff and third parties unrelated to Ripple. So as a result of that, the judge effectively right there, because that claim is accurate, invited the SEC to say, hey, we want to redact certain notes or certain portions of certain notes. Now, here's the problem for me personally. Like, I don't trust the SEC further than I can spit. I really don't. So, if the judge is going to see all of this and nothing could slip by, okay, that's one thing. But here's the thing. Attorney Jeremy Hogan, in this second tweet on the screen right here, he wrote in part, the SEC wants to redact even from Ripple and the judge in this specific case. It's not normal, but might make sense in light of the judge's order. So even the judge wouldn't know what's being redacted, or only that it is being redacted, so seeking permission from the court. So according to Jeremy Hogan there, we're just going to have to take the SEC at their word that they're acting appropriately. What? Like, nope. I don't know about you folks. And so there's the 4 instances that they want to redact. They're on your screen right now for the purposes of this video. I don't feel like I need to read through it. If you want to read it, again, it's on your screen. Just hit pause. I read through this, and it's like there's nothing on the surface. We're just reading the descriptions. You'd be like, oh, yeah, well, there could be something really important in there. You can't tell from the surface, but that doesn't mean that there isn't. So I don't know what's going to be redacted specifically. And I just don't trust the SEC. They have eroded trust among investors, including myself. They absolutely have. I just think that the SEC is a terribly damaging organization. And not that they literally don't do any good. They do. Like, they go after legitimate scams and frauds and stuff. That part's good. But man, I have a problem with this particular agency seeing the way that they're just trying to destroy the entire crypto asset class in the United States and just ruining people's lives. How can you respect them? I don't think they're acting ethically. I don't think they're acting morally. It doesn't matter to them. And I don't think they're operating in good faith on that front either. So I'm just saying, here you go. The SEC wants to throw a little redaction party for themselves. And I don't know what's likely as far as whether or not the judge is going to approve this or not. But either way, I'm just saying, I do not trust them. Now take a look at this from attorney John Deaton. Prediction. When someone finally asks Bill Hinman about the $15 million from Enterprise Ethereum Alliance member Simpson Thatcher, I guarantee he denies knowing that his law firm was a member of the Enterprise Ethereum Alliance. Save this tweet. And again, as I cited at the outset of this video, Bill Hinman, he did get $15 million. He's paid $15 million from his law firm, Simpson Thatcher, which is a member of the Enterprise Ethereum Alliance. And he gave a speech while getting paid all of that money, a speech that gave clarity, or at least perceived clarity at the bare minimum to market participants surrounding Ethereum specifically. And then he quit, and then he went to work for Simpson Thatcher again. The optics obviously very bad. And so here John Deaton saying, when somebody finally asked Bill Hinman about the $15 million from an Enterprise Ethereum Alliance member, Simpson Thatcher, he says, I guarantee he denies knowing that his law firm was a member of the Enterprise Ethereum Alliance. Save this tweet, he writes. Now, why is he saying that? Well, check it out. This is from John Deaton. Why am I so sure to guarantee my prediction? 1, it doesn't pass the laugh test, smell test, taste test, or any other basic ethics test. If he admits he knew Simpson Thatcher was a member of the Enterprise Ethereum Alliance, people will ask, why didn't you disclose it? Or, you agree it looks bad, right? But here is proof. In an email, Hinman tells his buddy at Simpson Thatcher that the ethics office is resisting him going to an ad hoc dinner if lawyers from Simpson Thatcher will be there. Dinner! No way Hinman cleared that speech with the ethics office knowing about the Enterprise Ethereum Alliance. So that's the whole comment from attorney John Deaton. So you get the point he's making here. The ethics office, he actually did go to the ethics office, and they didn't even want him to be in the same room as people from Simpson Thatcher at this ad hoc dinner event. He didn't even want, like, they were already serious ethics issues just from being in the same room at a dinner event. So if that's why he's saying, if the ethics office knew about him getting $15 million from Simpson Thatcher, do you think that the ethics office would have allowed him to give his June 14th, 2018 Ethereum free pass speech? Do you think the ethics office would have let him do that? That's why John Deaton wrote, and I quote again, no way Hinman cleared that speech with the ethics office knowing about the Enterprise Ethereum Alliance. So that's the claim that he's going to make. Now, as to whether or not you believe that, that's hard to believe. That's really coincidental. That's really super duper coincidental. I'm not so sure. I'm not really sold on that. And then John Deaton also wrote this on the same topic. Anyone who claims the conflicts and appearances of impropriety are conspiracy theories, show them this email about dinner. When the appearance of impropriety is so significant that it destroys the public's confidence in government, actual impropriety has occurred. And this is the email. I'll put it on screen. I don't want to read the whole thing, other than this one portion where Bill Hinman wrote to his buddy at Simpson Thatcher, our ethics folks were resisting my attending if Simpson Thatcher was going to be present. So the rest of it's on the screen if you want to read what John Deaton shared. But there you go. They had a problem with dinner. Okay, I don't think that had they known the deal about $15 million getting into the hands of Billy Boy Hinman, the ethics office probably wouldn't have been too thrilled about that. I think it's fair to state, right? And then there was this. Perianne Boring. She's the one that's on your screen in yellow on the right. She is I believe she's the founder, right? Yeah, founder of the Digital Chamber of Commerce. On October 8th, 2020, she wrote, XRP is not a security. That's the tweet. XRP is not a security. And she then shared this link to iflr.com. And this article is titled Cryptocurrencies and U.S. Securities Laws Beyond Bitcoin and Ether. Now, this is an article written by Chris Giancarlo, a former CFTC chairman, and also another attorney named Conrad Bulk, if I'm saying that right. This article I've covered on more than one occasion on this channel, so for the purpose of this video, I'm not going to, but they make the case for why they believe what they believe about XRP and how it's not a security, for lots of reasons that we've been discussing for over a year at this point. So Perianne Boring, who again founded the Digital Chamber of Commerce, all about cryptocurrencies and crypto adoption, so on and so forth, says XRP is not a security. And she's hitting the nail on the head. I certainly do appreciate that. But we haven't seen anything from the Digital Chamber of Commerce supporting or promoting Ripple and speaking out against the SEC to this point, right? And this quote, again, she said, XRP is not a security. That's October 8th, 2020, a couple months before the SEC actually sued Ripple. Now, somebody named Matt retweeted that tweet from Perianne Boring, where she wrote, XRP is not a security. She retweeted that just 7 hours ago, actually, and wrote, agreed, Perianne. So why have you refused to speak on this subject since this tweet of yours, which was 2 months before the SEC case against Ripple was announced? Did you know something then that we didn't? And Perianne actually did respond to that. And she wrote, we're submitting a brief and cannot comment until the brief is filed. Whoa, how about that? So they actually are going to be jumping in. They're going to be jumping into the fray. Attorney Jeremy Hogan thinks this is a rather good thing, so he retweeted that from Perianne and wrote the following. Good to see that the Chamber of Digital Commerce will file an amicus brief in the Ripple case. It filed an amicus in the Telegram case and focused on distinguishing the digital asset from any potential investment contract. Ooh, how about that? This is similar to what Attorney Deaton is arguing. Yeah, so it would be similar in the sense that, just like we're saying, oranges by the nature of oranges existing are not securities. XRP by the nature of XRP existing, it doesn't make it a security. It's the way that it's packaged. Like gold could be a security if it's packaged in a particular way. It's about the specific facts and circumstances. Bitcoin could be, XRP could be. That's different than saying that the asset itself is a security. And so what Jeremy Hogan's highlighting here is that in a separate case, the Telegram case, they're effectively making that argument. You know, again, he wrote here, it filed an amicus in the Telegram case and focused on distinguishing the digital asset from any potential investment contract. And then somebody from the community on Twitter wrote to Jeremy Hogan and said, filing an amicus brief would mean what exactly for the Ripple case? And Jeremy was kind enough to respond, and he wrote, they'll file a lengthy legal brief with Judge Torres that talks about the lack of clarity in the United States. Messed up the cadence of that. Let me just start that over. They'll file a lengthy legal brief with Judge Torres that talks about the lack of clarity in the United States market for crypto, and which will argue that even if Ripple sold XRP as a security back in the day, XRP is not in and of itself a security any longer. All good stuff. Now, this I'm not going to run through for the purpose of this video, but this is the Telegram brief, which Jeremy Hogan shared a link in the separate in a separate tweet. And you can see it's rather lengthy, so I'm just going to scroll through. I'm not actually going to read any of this, but you can see this is kind of lengthy, stable of contents, all sorts of information here. They're going to do this for the Ripple case, the SEC versus Ripple case, and they're going to be talking about XRP. So when that comes out, you better believe I'm going to be dissecting that thing and jumping in, and it'll be fun to talk about that because I'm anticipating that it's going to be in favor of Ripple and positive about XRP specifically, especially given that Perianne Boring has previously stated that XRP is not a security. I don't think that this little bitty time later, after the lawsuit, she would have magically changed her opinion. That would really be shocking. So I'm going to go ahead and guess no. Cool stuff, right? So we can look forward to that. But I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.